Do you really have a Second Amendment right if the federal government can still force you into a 1930s gun registry after Congress killed the tax behind it? That's the fight in Silencer Shop Foundation Vital ATF. And late last night, the self-styled most pro-2A Department of Justice ever showed its hand in a 48-page filing defending the National Firearms Act yet again. On July 4, 2025, the One Big Beautiful Bill Act wiped the classic $200 tax on suppressors, short-barreled rifles, short-barreled shotguns, and AOWs. Now the DOJ is arguing that the NFA survives anyway, propped up by special occupational taxes, the Commerce Clause, and old Supreme Court precedents like Sunzinski and Miller. What's really on the line isn't paperwork for a niche industry. It's whether ordinary Americans can own standard defensive tools without permanent federal tracking. In this video, I'll walk you through exactly what that means today. This case is particularly relevant if you own a suppressor, have considered filing a Form 1 for a short-barreled rifle, or are concerned about the future of the Second Amendment. The National Firearms Act, enacted in the 1930s, did not ban certain firearms outright. Instead, Congress imposed a significant tax on the manufacture and transfer of specific guns, required federal registration, and added a special occupational tax for dealers and manufacturers. This approach was presented as a revenue measure, and the "it's just a tax" rationale enabled the law to withstand early court challenges for nearly a century. Recently, Congress removed a central component of the NFA by setting the traditional $200 tax on most items to zero through the One Big Beautiful Bill Act. The tax stamp requirement has been eliminated for suppressors, most short-barreled rifles and shotguns, and any other weapons. As a result, organizations such as Silencer Shop Foundation, Gun Owners of America, and industry partners filed this lawsuit, arguing, if there is no tax, you can't keep calling this a tax law. The plaintiff's primary argument is that the federal government has long justified the NFA by claiming, we're not banning anything, we're just taxing it. The Supreme Court accepted this reasoning in cases such as Sunzinski, upholding the law on the grounds that it generated revenue. Now that the per-item tax has been eliminated for many NFA firearms, the plaintiffs assert that the NFA's legal foundation no longer exists. They argue that a national registry and related penalties cannot be maintained without the underlying tax. The second part of their attack is just as important. They are not asking for a one-off exemption or a technical fix. This is a facial challenge. That means they are asking the judge to say that, as applied to these categories of weapons, the NFA's registration and approval scheme is unconstitutional in every case. If they win at that level, it is not just one gun owner walking away from one case. It would force the federal government to rethink how it regulates suppressors and short barrels everywhere, for everyone. So how does the Department of Justice respond? They start by insisting that the tax story is not over, even if Congress wiped out the classic $200 tax stamp. DOJ points out that the NFA still imposes a special occupational tax on importers, manufacturers, and dealers who handle these items. In their view, as long as that occupational tax still exists, the registry, background checks, approvals, and even criminal penalties can be defended as tools for collecting that tax. They are trying to tell the judge, look, Your Honor, this is still a revenue scheme. Nothing fundamental has changed. But they do not stop there. And this is where we really see the federal playbook. The brief leans hard on the Commerce Clause. DOJ argues that suppressors, short-barreled rifles, and other NFA items overwhelmingly move in interstate commerce. They are designed in one state, manufactured in another, shipped across the country, and sold online or through national distributors. Even if you build one at home, they say it affects the broader interstate market. If that sounds familiar, it is because the Supreme Court used similar reasoning in the medical marijuana context. The government is essentially saying, if Congress can regulate homegrown marijuana because it touches the national drug market, it can regulate your suppressor because it touches the national firearms market. Then they add a third layer by reaching for the necessary and proper clause. This is the idea that Congress can pass laws that are not just directly about interstate commerce, but are necessary and proper to make its other regulations work. In practical terms, DOJ is arguing that even purely in-state manufacture and possession of NFA items can be roped in if Washington says it is needed to protect the integrity of the larger national gun control scheme. In other words, even if you never cross a state line, They claim your gear still gives them an opening under the Constitution. Up to this point, the DOJ has been arguing on grounds of the taxing power and the commerce power, but this case is also about the Second Amendment itself, and that is where their arguments get even more interesting. For short-barreled shotguns and similar weapons, they reach all the way back to a case from 1939 United States v. Miller. In that decision, the Supreme Court upheld the NFA's application to a short-barreled shotgun by saying there was no evidence in the record that such a weapon had a reasonable connection to a well-regulated militia. DOJ uses that language to argue that certain short-barreled firearms are dangerous and unusual, and therefore less protected by the Second Amendment than the handgun in Heller. When it comes to suppressors, the government's position is even more aggressive. In a recent decision from the Fifth Circuit, United States v. Peterson, the court held that suppressors themselves are not arms covered by the core of the Second Amendment. DOJ seizes on that line. If a suppressor is not an arm, then placing it behind the NFA's registration wall and approval process becomes, in their telling, a straightforward regulatory choice. They treat it almost like a muffler on a car, something that can be heavily regulated without ever raising a constitutional eyebrow. For the catch-all category of any other weapons, DOJ tries to plug those items into the historical tradition test that the Supreme Court laid out in Bruin. They point to how certain concealable or unusual weapons were treated in the 19th and early 20th centuries, and argue that there has always been a tradition of regulating such gear more tightly. They want the judge to see AOWs as the modern descendants of weapons that legislatures and courts have been skeptical of for generations. Put all of that together, and you start to see the strategy. Instead of squarely confronting the question of whether a nationwide registry for standard defensive tools fits within the original public understanding of the Second Amendment, the DOJ is trying to keep the focus on technical doctrines taxing power, interstate commerce, and fragments of older case law. They rely heavily on decisions made decades before the Supreme Court clearly recognized an individual right to keep and bear arms. They highlight Sunzinski and Miller, but they downplay the modern shift in cases like Heller, McDonald, and Bruin, which recognize the right as a limit on government. Why does that matter to you? Because if DOJ's approach wins, it sends the message that Washington can keep using the tax code and the commerce power as backdoors around the Second Amendment. Congress can set a tax to zero, tell voters they delivered relief, and still have agencies like ATF and DOJ stand up in court and insist that nothing important has changed. Meanwhile, the registry remains, the approvals remain, and the risk of federal felony charges for paperwork mistakes remains squarely on the shoulders of ordinary gun owners. On the flip side, if the challengers make real headway on this facial challenge, it will be the first time in nearly 90 years that a federal court has seriously questioned whether the NFA structure itself still fits within the limits of the Constitution. A strong ruling in their favor could force Congress to either rebuild this entire system on a new constitutional foundation or accept that suppressors, short-barreled rifles, short-barreled shotguns, and similar items need to be treated more like other commonly owned firearms. That is why so many people on both sides of the gun debate are watching this case so closely. Procedurally, this is still an early-stage fight in a federal district court, and there will be motions, hearings, and eventually appeals. But everyone involved knows where it is headed if the stakes remain this high. Any serious ruling will likely go up to the Fifth Circuit, and from there, it becomes a prime candidate for review by the Supreme Court. In other words, this is not just noise on a docket sheet. Understanding how DOJ is arguing now helps you see exactly what they may try next. No matter which party controls Washington or who sits in office, it is one of the clearest paths we have seen in decades for the courts to revisit how far the federal government can go when it uses taxes, paperwork, and criminal law to control the exercise of a fundamental right. At the end of the day, this isn't just about one lawsuit or one company. Silencer Shop Foundation v. ATF is a test of whether the federal government can use an 80-year-old tax scheme to keep tracking and criminalizing ordinary Americans who simply want to own modern defensive tools. When DOJ tells a court that the tax is gone but the registry lives on, they are saying that your rights exist only as long as Washington chooses not to punish you for exercising them. My promise to you is simple. I'll keep reading the filings, translating the legal jargon, and calling out government overreach whenever it targets lawful gun owners. If you want to stay ahead of what ATF, DOJ, the Fifth Circuit, and the Supreme Court are doing to the Second Amendment, make sure you're subscribed, hit the bell, And share this video with every gun owner you know.